So I'm going to talk about the presidential records cases, the financial records cases, say a little bit about how the same phenomenon that causes us to do these programs this way required some changes to the Supreme Court. Before I get into that, though, I did want to say a little bit about Justice Ginsburg, who, as everyone knows, passed over the weekend. She died tragically on Friday from complications from pancreatic cancer. And for those that are interested, and I will post this in the chat, I just posted a link. We're doing an event tonight at 7:30 at the law school through Zoom, of course, that will feature me, Professor Jonathan Enton, who clerked for Justice Ginsburg when she was a judge on the DC Circuit, my colleague Jesse Hill, and my colleague Ray Koo, and that will be moderated by Professor Sharona Hoffman. That's tonight at 7:30. I'm pretty sure a video of the event will also be available on our website shortly after tonight as well, for folks that want to know more about the life and legacy of Justice Ginsburg. She obviously touched a lot of folks. Her work's been incredibly important. This is a picture from yesterday in front of the Supreme Court. So obviously it's very significant and could devote the whole lecture to her, but as a good professor, my aim was to stick with the syllabus. I will say a few things about her career, about her life, just because I think it is worth noting. Here are a few factoids. She was born in Brooklyn in March of 1933. She attended Cornell University. She enrolled at Harvard Law School in 1956. She did not graduate from Harvard Law School because her husband, Marty Ginsburg, got a job in New York. Harvard would not let her continue to stay enrolled in Harvard Law School if she was not in Cambridge, so she transferred to Columbia Law School and so was graduated from Columbia Law School in 1959. Harvard apparently tried to give her a JD later on, and she said no. They had their chance, but has received or did receive honorary degrees from Harvard. She, like was true of other women who graduated law school at the time, it was hard to get hired. She had a fellowship. She did some work researching civil procedure in Sweden, actually learned to speak Swedish before obtaining a job teaching at Rutgers Law School, where she was awarded tenure. Then she taught at Columbia, returned to her alma mater, and helped found the ACLU Women's Rights Project, where she litigated quite a few cases involving gender equality before 1980, when she was nominated to the U.S. Court of Appeals for the DC Circuit by President Jimmy Carter. She served on that court until 1993. She was nominated to this U.S. Supreme Court by President Bill Clinton in June of 1993, confirmed just 2 months after her nomination in August of 93 by a vote of 96-3. And of course, she died this past Friday at the age of 87. What other tidbit? The Time magazine cover I've put on the slide about the 100 most influential people, included essays about various icons that Time magazine wanted to honor. The essay on Ruth Bader Ginsburg was written by her close friend, Antonin Scalia. As I assume folks know, the two of them were very close friends in their time on both the DC Circuit and on the Supreme Court. Given how politically polarized we are, I'm among those that think it's worth remembering how close the two of them were, despite their quite stark political and jurisprudential differences. there's a fun story that Judge Jeff Sutton tells of being in Justice Scalia's office, and Justice Scalia, I guess, apparently had a bouquet of 24 roses he was preparing to give to Justice Ginsburg for her birthday. And Judge Sutton said to Justice Scalia, you know, all this effort, all this, you know, all these niceties and so on, you know, but when has it ever made the difference in a 5-4 case? When did it ever change her vote? And according to Judge Sutton, Justice Scalia's reply was that some things are more important than votes. So they had a truly wonderful friendship that is worth remembering, in addition to obviously remembering her important legacy as both a litigator and pioneer for gender equality, as well as an important Supreme Court justice, and only the second woman to serve on the Supreme Court. So I wanted to say a little bit about her before proceeding to the scheduled material. And again, there is a program tonight, and the link for information to that on that program is in the chat for today's the chat box for this lecture. Justice Ginsburg was certainly on the court for this past term. Here is a picture of the court as it was constituted this past term when the court heard the cases concerning the president's financial records. I've put a slide on a picture from C-SPAN, and if you note on C-SPAN it says Supreme Court Live, because for the first time we were able to hear Supreme Court oral arguments live as they were happening. There were telephonic arguments, and this is the first time this happened was this year because of COVID-19. This was not the first time the Supreme Court had postponed arguments due to a pandemic. This had occurred before, but it was the first time that part of the response to such postponing was allowing the live streaming of any portion of Supreme Court arguments. Traditionally, the Supreme Court records the audio of its arguments, does not allow video of any of its proceedings, and that audio from arguments traditionally is released on the Friday after the argument. So if arguments are heard Monday through Wednesday or Monday through Thursday, the audio is released Friday afternoon of that week. A written transcript is often released the same day, but not the audio. But after the Supreme Court decided to put some of its oral arguments on hold because of the pandemic, and then scheduled makeup arguments in May, and the financial records case was one of these arguments argued in May, they decided to allow the audio stream from the telephonic arguments to be released live. And the Supreme Court will be doing this again at least this October for the first arguments of the current sitting. Just a quick side note, you know, some courts have gone full Zoom. Some courts have done what we're doing today. Here is a screenshot from a argument of the Texas Supreme Court. So some courts have fully embraced technology to deal with these difficulties. The U.S. Supreme Court is a little bit behind on its embrace of technology. So for example, we get the audio, and what C-SPAN has done is while it plays the audio, it shows the pictures of the justices and the advocates. This is a picture from the first case in which telephonic arguments were streamed this year. It was a case involving whether or not Booking.com could trademark Booking.com. And so Lisa Blatt, a very prominent appellate advocate in DC, was the guinea pig, the first person to have to begin an argument over the phone to the Supreme Court. One thing about the oral arguments that have been very different that is also worth noting is that traditionally the oral arguments are a bit of a free-for-all. The advocate gets up a minute or two into their argument, the questions just start coming, and they can come from anyone. After that first minute or so, it can be very hard to get a word in edgewise. To account for the fact that when you're over the phone, you can't see the visual cues and see when someone's trying to get in or not get in to the questioning. The Supreme Court adopted a practice of seriatim questioning. So each justice getting a set amount of time to ask questions of each advocate on each side of the case. And that definitely changed the dynamic. Among other things, we saw very active questioning from Justice Thomas, who very rarely asks questions in traditional oral arguments. But in these arguments, we saw him use his time very aggressively. As the second senior most justice, he was always the second questioner. And it was interesting how not only to hear what sorts of questions he asked, but his questions generally set the tone of the argument. It was interesting to see other justices pick up on and follow up on issues that he raised during his questioning throughout all the cases that were argued in May. One last little bit on the change in arguments. There was a bit of a snafu. I don't know if any of you, in using Zoom for programs like this or conversations with family members or friends, have occasionally forgotten to mute or forgotten to unmute. Well, it's okay. It happens to Supreme Court justices too. There was a mystery flush that was heard on one of the arguments, and Slate magazine actually published an article in which one of their reporters tried to uncover and figure out which one of the justices had forgotten to mute and which one of the justices was responsible for the errant sound of a toilet flushing during oral argument. Her conclusion was that it was Justice Breyer, but there has been no official confirmation from the court. So enough of the preliminaries. I want to talk about the cases, the two sets of cases. They were argued on the same day. One of the cases, Trump was actually a consolidation of two cases, Trump versus Mazars and Trump versus Deutsche Bank AG, concerning congressional subpoenas for the president's financial records. And then the other case, Trump versus Vance. An interesting thing just to start off with, a question might be, why are these cases like Trump versus Mazars? Mazars is Trump's accountant. Mazars LLP is the accounting firm that handled Trump's financial dealings, as well as those of his family members and various Trump-related businesses, Trump Incorporated and a bunch of holding companies. Why is this case styled Trump suing his accountant? Well, the reason is that in the first set of cases, these involved congressional subpoenas, not to Trump, not to the White House or the office of the president, but subpoenas to the accountants and the banks for Trump's financial records. So these were subpoenas to the third parties that had access to or had copies of the relevant records. And so Trump filed in court in these cases, as well as in Trump versus Vance, which concerned a grand jury subpoena to Trump's accountants. Trump's attorneys filed to try and quash or block the subpoenas. So basically, in the congressional cases, Congress issued subpoenas to these private parties. In the Vance case, the New York District Attorney's Office grand jury issued a subpoena to Trump's accountants. These private firms generally would do what anyone would do, or what most of us would do if we receive a subpoena, is we'd comply. We don't want to be held in contempt. And so to prevent that compliance, Trump's attorneys filed these cases trying to quash or block the subpoenas, basically seeking an order from the court telling the third parties, the accounting firm and the banks, do not comply with this demand for documents. And in both cases, Trump had lost in the lower courts. In the congressional cases, there was a judgment from the Second Circuit Court of Appeals in the Deutsche Bank case, and from the U.S. Court of Appeals for the D.C. Circuit in the Mazars case, both upholding the congressional subpoenas. And in Trump versus Vance, there had been a lower court decision from the Second Circuit upholding the grand jury subpoena. So what I'm going to do is I'm going to talk first about the Vance case, what I think is the more straightforward of the two cases, and then, as is traditional, we'll take some questions and about that case and have a break, and then come back and talk about the Mazars case, and of course we'll have time for questions at the end of that discussion as well. So let's talk about the Vance case. So this is a New York grand jury subpoena to Trump's accountants seeking financial records of Donald Trump's, of his family members, his Melania, his children, their financial records from various Trump-related enterprises. And basically, the New York District Attorney's Office had assembled a grand jury. That grand jury was investigating criminal wrongdoing of some sort, and pursuant to that inquiry, sought a grand jury subpoena. These subpoenas were prompted in part by testimony of this fellow, Michael Cohen, who, as I think you all know, was one of Trump's attorneys, often characterized as Trump's consigliere, Trump's fixer, as the attorney that was tasked with trying to solve various problems. And among other things, Michael Cohen was prosecuted and pled guilty to some campaign finance violations, including alleged payments that were to a woman who claimed to have had an affair with Donald Trump. And basically, Michael Cohen arranged for a payment to this woman during the presidential campaign. And depending on where that money came from, that could have been a campaign-related expense that had to be reported. And after Michael Cohen pled guilty to these crimes and gave testimony raising some other potential allegations against the president, the New York grand jury said, well, there may be financial improprieties here that occurred in New York. We want to investigate. And so they are investigating allegedly a bunch of things, possibly related not only to Donald Trump, but also to his business affairs. Among other things, there have been reports that some of Trump's businesses may misrepresent some of their financial valuations on some documents. For example, presenting one set of valuations when doing things like seeking bank loans, but then presenting a different set of valuations when doing other things like paying their taxes. And Trump, unlike any other president in the last 40 years, did not disclose his tax returns during the campaign. So there is there are a lot of questions about his financial dealings, and the New York grand jury was seeking to obtain those documents. One other piece of background that's important here is it is generally assumed that that a president, while in office, is immune from criminal prosecution. That's certainly true for any official acts taken by the president. But even for unofficial acts, a federal prosecution would not be possible because the Justice Department is under the control of the president, because the Attorney General serves at the will of the president. The president can at any time fire the Attorney General. And so it's given that it's unlikely that the Attorney General's office or the Department of Justice would ever indict the president. And there are Justice Department memos saying that the president can't be indicted by the federal government, cannot be indicted by the federal government. It is generally assumed that this would preclude the prosecution of a president while in office by a state or local prosecutor. But the question would be open about, and was open in this case, about whether or not the prohibition on prosecution would extend to investigation. And one reason it might not is because in our legal system, we generally place a value upon resolving legal questions quickly, on prosecutions occurring quickly. We have a speedy trial right. Our evidentiary rules recognize that over time, evidence may be lost, evidence may become less clear or less probative, and so there is a value in letting investigations proceed. The other important piece of background relates to the grand jury case is that we had some cases involving President Clinton, involving whether or not a president could be subject to legal proceedings based on private non-presidential conduct, and in particular conduct that occurred prior to becoming president. And in a case called Clinton versus Jones, which I assume most of you are at least somewhat familiar with, President Clinton was sued by Paula Jones for sexual harassment based on conduct that allegedly occurred when he was the governor of Arkansas. But the suit was filed while he was president. Bill Clinton's attorneys argued that he could not be subject to such legal process. He could not be subject to suit and discovery requests and document production requests and the like while he was president. And the Supreme Court unanimously rejected that. The Supreme Court said that we have never suggested that the president has an immunity that extends beyond the scope of any action taken in an official capacity. And so the argument that was made by the New York U.S. Attorney's, or sorry, the New York District Attorney's Office was that this same principle means that Trump is not immune from legal process concerning potentially criminal activities he or his businesses may have been involved in prior to becoming president. So, for example, if one of his hotels or businesses committed tax fraud or some other financial crime prior to Trump becoming president, his presidential immunity would not cover that. Trump, on the other hand, argued that he should be immune, that there should be absolute immunity against criminal prosecution, arguing that Clinton versus Jones was a civil case, but that the burdens and stigma and imposition of a criminal case is greater than a civil case. He further tried to argue that a state proceeding would be a greater imposition than a federal proceeding. That Clinton versus Jones was a federal case, that in federal court, federal judges could be trusted to take account of and accommodate the needs of the president and the demands of the office, whereas a state court might not be so accommodating. And for federalism reasons, that allowing state proceedings would unduly interfere with the discharge of his duties, especially if it were a criminal proceeding. Well, the Supreme Court did not think very much of these arguments, ultimately deciding 7-2 to affirm the judgment of the U.S. Court of Appeals for the Second Circuit that the president did not have any sort of immunity from criminal process while in office, insofar as that criminal process is focused on non-official acts, non-official activities. And that's important. So this is not a local district attorney trying to get documents that could be covered by executive privilege. This is not an effort to get information about the inner workings of the White House. This is about obtaining information of the sort that any of us, were we within New York's jurisdiction, were we engaged in financial activities in New York, documents and matters that we would have to disclose, that we would have to respond to. And Chief Justice Roberts, in writing the majority opinion, began his opinion with a very important principle, one that underlies the judgment in this case, that in our judicial system, the public has a right to every man's evidence. Since the earliest days of our republic, every man has included the President of the United States. This was the principle that underlay the Supreme Court's unanimous decision in Clinton versus Jones, And for a majority of the court, this principle dictated the outcome in Trump versus Vance, that the president, when he is engaged in private financial matters, is like the rest of us, is no more immune to investigation than the rest of us. And not only did this mean he did not get any sort of immunity from process or investigation, but in addition was not entitled to any additional protection in the form of some more stringent test. So 7 of the justices, as I mentioned, agreed with this outcome. I've organized the justices this way on the slide because Chief Justice Roberts wrote for himself and the 4 liberal justices, Justices Breyer, Sotomayor, Kagan, and Ginsburg, rejecting presidential immunity, but also saying that there was no heightened need or heightened standard that had to be met to obtain the relevant documents. Justices Kavanaugh and Gorsuch, interestingly enough, the justices appointed by President Trump, agreed with the bottom line of the Chief Justice's opinion. They concurred in the judgment, so they voted to affirm the judgment of the U.S. Court of Appeals for the Second Circuit, the court below, that there was no barrier or obstacle to the district attorney subpoenaing these documents for the grand jury, and that the president could only raise specific objections to specific documents or the sorts of objections that any ordinary citizen would be able to raise on remand. They wrote separately to argue that they thought that the president was entitled to a little bit more protection than Chief Justice Roberts' opinion suggested, that some sort of heightened need standard was justified, but because they concurred in the judgment, they felt that standard had been met in this case. Justice Alito and Justice Thomas both dissented from the judgment. It's interesting, though, that they both rejected the claim of absolute presidential immunity that Trump asserted. So all 9 justices agreed that the president does not have any sort of absolute immunity from judicial process, such as a grand jury subpoena. Justices Alito and Thomas dissented because they thought that the U.S. Court of Appeals for the Second Circuit was not accommodating enough of Trump's claims to protection from turning over these documents. Justice Alito thought that there were legitimate concerns that if you allowed local prosecutors to investigate the president, that you face the risk of there always being a local prosecutor somewhere or a state attorney general somewhere in the country who would want to harass the president or investigate the president, and that was a Pandora's box that the court should be very concerned about opening. Justice Thomas argued that while the subpoena could issue, he wasn't sure that the subpoena could be enforced. He felt that the president needed to have the opportunity to make the argument that demands on his time and attention could bar the enforcement of the subpoena. So they thought that the president's arguments against this particular subpoena should be given more merit or more weight, but they did ultimately reject the claim of absolute immunity. What this has meant is that this case went back to the lower court, where the president has again been raising a new set of objections to the breadth of the subpoena, claims that it's a fishing expedition, claiming that it's seeking documents that are not necessary for a legitimate criminal investigation. The district court rejected those claims. Those claims are on appeal to the Second Circuit and will likely be resolved relatively quickly. I would note that while these claims might be resolved relatively quickly, that does not mean that we will get to see any of these documents, because it's important to remember that what's at issue in the Trump versus Vance litigation is a subpoena sought by the New York grand jury. And under grand jury secrecy laws, any documents that are obtained by the grand jury under subpoena remain confidential. They remain secret. The idea here is that in investigating possible wrongdoing, the grand jury, on the one hand, may obtain documents of people that have done nothing wrong, but that may nonetheless be embarrassing and that the public does not have a right to see. But also that the decision about whether or not to seek an indictment or not is something that is ultimately in the hands of the local prosecutor, and not every bit of information that looks bad or that's potentially incriminating necessarily justifies criminal process, and that this sort of information should not be released or revealed unless and until there is a criminal indictment. So while we expect the final resolution of the continuing legal wrangling in this case to be resolved relatively quickly, it's not going to mean that we get to see the documents. It does not mean that we will finally get to see Trump's tax returns. It means that the New York grand jury will be able to see these documents, and the New York grand jury will ultimately make a decision about whether or not to indict the president, to indict one of his businesses, to indict one of his family members for various financial improprieties. Another thing that's important to note is that sometimes grand juries will issue indictments that are under seal, or what's it called, a sealed indictment. So it's certainly possible they could ask the grand jury to indict the president, but would not act upon that indictment until the president has left office. One reason for doing that is you can take advantage of obtaining the evidence now, so you don't have to worry about evidence being lost or destroyed or otherwise despoiled, but hold on to the indictment and wait for the president to leave office so as to eliminate any arguments the president might have about whether or not he can be criminally prosecuted. And while this Supreme Court decision affirmed the power of the grand jury to investigate the president, it said nothing about the ability of the grand jury to indict or of the ability of a local prosecutor to actually prosecute the president. The court basically said, look, the president's evidence is every man's evidence, and the legal process has the right to that evidence for purposes of investigation, and that is unlikely to be an undue burden on the president. The president telling his accountants, yes, comply with the subpoena. Thank you for letting me know what documents you are turning over, giving the president the opportunity perhaps to identify materials that might be privileged, that don't have to be turned over. That process is not so burdensome as to interfere with the president performing his duties, especially if, as the court indicated, courts are under an obligation to hear out any claim of burden to a specific document request if that is raised, but that actually subjecting the president to prosecution could be something else entirely, that the nature of criminal process, what is demanded of a defendant and so on, would be a different matter. So in terms of the ultimate implications of this first case, we have yet to see. We will see. We don't know for sure whether the president has committed offenses that could be prosecuted under New York law. We don't know if the president or his businesses have committed offenses that the New York DA believes are worth prosecuting. But the court did reaffirm the principle that we have a president, not a king, and that in terms of the president's private affairs, his private business dealings and the like, he is not immune. While courts may need to take account of the fact that the president has certain legal and constitutional obligations and demands on his time that need to be accommodated, that does not translate into any form of immunity. And that is why not only this case goes forward, but it's also why many other cases, both particularly various civil cases against Donald Trump, raising various claims about conduct he allegedly committed or engaged in prior to his becoming president, are continuing to proceed in the lower courts. So I think I will pause. There for a moment to see if there are questions about this first case or about how the Supreme Court has been handling matters during COVID-19, and then we will take our break and then go to the second case after the break. So I don't know if people have just been speaking up or if people want to use the hand raising function, but either way is certainly fine with me.
People have been doing all sorts of things, basically, either raising their hand, or you can use the chat feature, or just unmute yourself and play.
Okay, I don't see any questions.
I have a question.
Sure.
Is Trump paying his lawyers, or is Barr going to step in and make us pay for these cases like he did with the woman who was suing Trump over defamation?
Okay, so in these cases, Trump was represented personally by a firm called Constable Park, or Constable McCarthy and Park. The Justice Department also filed separately in these cases. The position taken by the Justice Department and the position taken by Trump's personal lawyers was not quite the same in each of these cases. So, for example, the Justice Department did not argue for absolute immunity in Trump versus Vance, while Trump's private lawyers did. And so he's paying for his private lawyers separately. The question alluded to a case that has been in the news recently. As I assume folks know, somewhere in the neighborhood of 24 women have alleged that Trump engaged in either harassing behavior or sexual assault or some other sexual improprieties. In one of these cases involving a woman named Jean Carroll, Trump, she, I guess, made these allegations in a book. And Trump was asked about these allegations by the press while he was in office. He claimed not to know her, not to have met her, made some comment to the effect of her not being attractive enough to have assaulted or not being his type, and other offensive comments, prompting Jean Carroll to sue him for defamation. What the Justice Department did a week or so ago is under something called the Westfall Act. So under the Westfall Act, when a federal employee is sued for allegedly tortious conduct that occurs during their activities, they can ask the Justice Department to certify that under the Westfall Act. And what the Westfall Act provides for is at that point, the federal government assumes a liability and responsibility for that case under the Federal Tort Claims Act, and the federal government defends them. The kicker is that the Federal Tort Claims Act only allows you to sue the federal government for certain sorts of torts. So the Federal Tort Claims Act waives the federal government's sovereign immunity. So the president is not absolutely immune for private conduct, but the federal government, it does have itself has sovereign immunity and can only be sued for the things that it has said it's okay to sue it for. And defamation is not a tort that you can sue the federal government for. So if the federal government puts out some document that says all sorts of terrible things about you, you cannot sue the federal government for defamation. So when the Justice Department certified this case under the Westfall Act, on the grounds that Trump's answers to the press and responses to the press were in the course of being asked questions as president because he was president, this meant that Jean Carroll's suit is now against the federal government, It is a suit for defamation. And because of the statute of limitations, among other things, she is not suing the president for sexual assault. She is suing him for defamation based on the comments he made as president. Defamation is not something you can sue the federal government for, so the case gets dismissed. So that is the kerfuffle that happened a couple weeks ago. And I should just note the case law on under the Westfall Act from lower courts. We don't have any cases on point from the Supreme Court, but the case law from lower courts kind of supports the president's position. So there's a case called Ballinger from the DC Circuit, in which case a member of Congress was asked about matters related to his divorce. And he was asked as a member of Congress, and he said some allegedly defamatory things, not about his soon-to-be ex-wife, but about a separate organization. He was sued for defamation. Westfall Act was invoked, case dismissed under the Federal Tort Claims Act. Even though his comments were related to his divorce, they weren't related to his actions in Congress. Another case more recently from the U.S. Court of Appeals for the Sixth Circuit, so that's the appellate court here. This was a suit against a member of Congress and against Senator Elizabeth Warren for allegedly defamatory comments they made about students at a high school that were involved in some confrontation during a protest in front of the Lincoln Memorial. Disparaging comments were made about the conduct of students at this high school, and then the students at the school sued Senator Warren, and this other member of Congress also sued a bunch of news organizations, several of which have settled their lawsuits. And the Sixth Circuit said these comments were, because they were comments made by public officials that no one would have cared about had they not been public officials, are in the course of their performance of their duties, certified under the Westfall Act, defamation case or claims dismissed. I don't like these lower court opinions, but these opinions, especially the Ballinger case from the DC Circuit, suggest that the Attorney General might have been correct to certify the case, at least under these lower court decisions, but that might go up to the Supreme Court. There's a question I see in the chat about oral arguments. We will have oral arguments in beginning in October under the usual schedule. So the Supreme Court will begin oral arguments the first Monday of October, as is traditional. They will just be telephonic arguments that are streamed live, or the audio will be streamed live. As that question notes as well, one of the cases that people are following closely is a case involving Obamacare, which will be argued on November 10th. Another question in the chat about Michael Cohen. Michael Cohen did testify against Trump before Congress. He has given testimony and is in pleading guilty to certain criminal offenses, did make claims about what Trump allegedly is involved in. There's a dispute about whether or not Michael Cohen is the most reliable witness. At various times, he's told enough different things, said enough different things about Trump-related affairs at enough different times that some people aren't sure how reliable he is. But he did testify before Congress about various things. In terms of the Mary Trump, I haven't followed the Mary Trump book very closely. That lawsuit was a purely private suit, alleging that there was some sort of agreement within the family to not disclose certain information as a condition of being able to inherit certain money, as opposed to the John Bolton book, which was where the litigation about that is about whether John Bolton, as a former government employee, is bound to not disclose classified information, and that people that have national security positions in the federal government traditionally have to agree to that sort of limitation. As for Bill Barr acting this way, as I mentioned, at least with regard to the Jean Carroll litigation, if insofar as the DC Circuit's opinion in the Ballinger case is correct, what he did with regard to the Jean Carroll case is potentially proper. I would note, though, that this is one of many cases against the president. So there are other cases against the president for defamation, other cases against the president for alleged sexual assault and other actions. Those cases are not covered by what Barr did in this case, because they are not based on actions that Trump allegedly engaged in while he was in office in any way connected to his being president. The hook in the Jean Carroll case is that here's Trump, at a press conference or at a press availability that was created for, because he is president. He is being asked these questions only because he is president. And in the course of that, someone, instead of asking him about, some trade deal or some political matter, instead asks him about Jean Carroll. And at that point, he says the things that are allegedly defamatory. And so that's the basis for the claim that was within the scope of his presidential duties. We have time for one or two more questions, I guess, or maybe one more question before our break. Is that right, in terms of the schedule?
Sure. Yeah, Don, you were about to ask a question before. Did you want to?
Well, excuse me. I'm still not completely clear. What's the current status of Trump's financial records?
Well, insofar in his financial records with regard to the New York grand jury, because we haven't gotten to the congressional cases yet. The district court has said start producing, but his attorneys are have made an additional set of objections, which the Supreme Court opinion said he could make, that aren't about immunity. So they aren't objections that are tied to his being the president. They're the sort of objections that anybody could make about this being a fishing expedition, this being the requests being overbroad, and so on. The actual order to produce the documents is on hold pending resolution of his appeal, and that's before the Second Circuit. The Second Circuit has indicated that it is going to deal with this very quickly. I assume he will try and go back up to the Supreme Court. I would be very surprised if the Supreme Court is interested in micromanaging the grand jury. All right, the Supreme Court has an interest in this big question about presidential immunity, not very interested in, what is an overbroad subpoena under New York law. So my expectation is that the litigation with the New York grand jury will be over relatively soon. That does not mean we see the documents. It means the grand jury sees the documents, and the grand jury will be covered by grand jury secrecy rules. So we would only know what the documents reveal if either there's a leak, which is possible, but given that the Supreme Court expressed some concern about leaks, I don't think the New York District Attorney's Office is going to be leaking this material, or if and when there are indictments. So the New York Grand Jury's Office has in the last week or so indicated a broad range of potentially criminal activity related to Trump businesses or those that have been engaged in business with Trump. One of the reasons why, and I should have mentioned this before, one of the reasons why presidential immunity in this context would be so problematic for our legal system is that if the president is immune, that would essentially mean that Don Jr. is immune, Eric Trump is immune, Trump's businesses, which are legally separate entities, are immune. I mean, Trump tried to argue that his immunity as president would cast this umbrella over all of the related family members and enterprises. And that would mean all sorts of entities and individuals who are not the president would be protected from criminal prosecution. And that would be hugely problematic. And so one way we might learn what's in these documents is not necessarily with an indictment of the president or one of his businesses, but what if we could see, for example, an indictment of Deutsche Bank for activities it was involved in that may or may not have related to the president's businesses. The New York District Attorney's Office has indicated that their investigation is quite broad and includes not only Trump-related businesses, but also those that have been engaged in business with Trump-related businesses. And the Trump-related documents are relevant not only to investigating the president, but also are relevant to investigating those whom the president has been in business with. And so we might learn something about that, because there could be an indictment soon. On the other hand, and I'll close with this before we go to our break, if the New York District Attorney is considering filing charges against Donald Trump himself, my suspicion is that they would obtain the indictment and then keep it under seal until Donald Trump is no longer in office, solely to not have to litigate these questions all over again and litigate the questions of, can you indict a sitting president? And the last thing I'll just note here too is it's important to remember this is a investigation under state law. So the pardon power is completely irrelevant. The pardon power only extends to federal crimes. What the New York District Attorney's Office is investigating are potential state crimes. And so while the president has the ability to pardon all sorts of folks for federal stuff, and my guess is we will see more pardons between now and January, if not beyond, he cannot pardon himself, his businesses, his family members for anything that related to state offenses. So that's a long way of saying we'll see. But I guess we should take a break, right, for 10 minutes. Is that what we normally? My clock says 2:25, so at 2:35, we will start back up. righty. Just find one thing here. All right. Ready to get, did I share my screen? Yes. You guys see my screen? Yes, the slides? All right.
Yes, yes.
All right, there we go. I have so many windows open, I'm sometimes losing track. Okay. Oh, that's fine. Okay. All right. So I want to talk now about this other set of cases, this pair of cases, Trump versus Mazars and Trump versus Deutsche Bank. These are two cases that arose out of congressional subpoenas. So this is not the grand jury trying to get information. This is not a prosecutor. This is Congress. And in April 2019, 3 separate congressional committees each issued subpoenas to third parties seeking financial records of the Trump family and the Trump organization. One subpoena was issued by the House Committee on Financial Services, focused on financial reform and claims that potential improprieties and alleged improprieties by various Trump-related businesses could serve as a case study for how Congress could reform banking laws to prevent evading or getting around existing banking laws and ensure more effective enforcement of those laws. The House Permanent Select Committee on Intelligence issued a subpoena arguing that these records and financial documents were necessary for it to investigate the potential counterintelligence threat posed by Trump and his businesses' relationships with foreign countries and businesses in foreign countries, concerns that either emoluments or business deals in Russia or business deals in Turkey and the like may have created some sort of intelligence risk or foreign affairs risk. And then thirdly, the Financial Services Committee, or sorry, I mentioned the thirdly, the House Committee on Oversight issued a subpoena seeking documents from Mazars of the president's and various affiliated businesses. And as I meant, each committee identified slightly different reasons for their subpoenas. All of their subpoenas were incredibly broad, and all were based on their claims that they needed information in order to perform their legislative function. And this is important, and this is something that I will come back to later, is that none of these requests for documents were in any way related to Congress's impeachment power. All of these committee subpoenas were expressly and explicitly based upon the House of Representatives' power to engage in oversight pursuant to or in order to facilitate legislative action. So the Financial Services Committee claiming that it might want to reform various laws relating to banks and financial institutions, and that this was an adjunct to that. The Oversight Committee saying that it is engaged in legislative related oversight. The Intelligence Committee likewise engaged in legislative related oversight of intelligence agencies and activities. And this is important because it meant the question before the courts was whether or not these subpoenas could be justified for a legitimate legislative purpose. So not at issue in these cases is whether Congress could seek these sorts of documents pursuant to an impeachment inquiry, but rather these sorts of documents could be sought for as part of an investigation, as part of Congress's legislative power. The lower courts, the U.S. Court of Appeals for the D.C. Circuit in the Mazars case, and the U.S. Court of Appeals for the Second Circuit in the Deutsche Bank case, which also included subpoenas that were issued to Capital One, both concluded that Congress could seek such information pursuant to a legitimate legislative purpose, that these subpoenas, as broad as they were within the bounds of legitimate legislative purpose. Both of these decisions, I should note, were divided. In both of these cases, the three-judge panels split. There were dissents in both the Mazars case in the DC Circuit, as well as the Deutsche Bank case in the Second Circuit. In both cases, there was one judge on the panel that thought that Congress's demands for documents were broader than could be justified under its legislative powers. As with the grand jury subpoena, these subpoenas were justified in part based on information that Michael Cohen disclosed when he testified before Congress. So when Michael Cohen pled guilty to certain offenses and then testified before Congress, he made lots of claims about things that Trump or his businesses may have been involved in, and this was the attempt by the committees to obtain these documents to investigate or verify some of the claims that Michael Cohen made. The Supreme Court accepted cert in both of these cases, and one of the things that was really interesting about the oral argument in these cases is it became very clear almost right away in the oral argument that the Supreme Court was uncomfortable with the breadth of authority that Congress was asserting. Congress was represented by Douglas Letter. He's the general counsel for the U.S. House of Representatives, and he was asked multiple times during the course of oral argument by justices across the board about whether or not there was any information about the president, any private information related to the president's personal affairs that Congress could not ask for. And he came up empty. The justice said, well, if Congress can ask for this, could they ask, is there any, could they ask for his medical records? Could they ask for, financial records of his grandchildren? And Douglas Letter didn't have an answer. Initially, he thought about saying, well, maybe Congress couldn't demand the president's medical records, but then he realized that under the 25th Amendment, the president's fitness for office, physically, medically, is an issue. And the way the 25th Amendment operates is that is among other things, it deals with presidential incapacity. So if Congress is trying to enforce or operationalize the 25th Amendment, the president's medical records would be just as relevant to that, both in terms of monitoring the existing president, but also in terms of a case study of how one might need to approach this question. His medical records would be just as relevant to that as his financial records are to a case study of the financial system, or a case study of how individuals might seek to avoid complying with various banking regulations and the like. Further, he realized that because Congress can propose amendments to the Constitution, that Congress's enumerated powers under Article 1, Section 8 are not even a limit to its oversight power, as Congress was arguing in this case, because Congress could always propose new powers. And if Congress was engaged in legislative investigation and oversight to determine what new powers it could need, well, that would justify just about anything. And this prompted a lot of discussion online, on Twitter, and in newspapers and elsewhere about why the General Counsel for the House of Representatives answered these questions in this way. One possibility, which we never like to think about, given that this was a Supreme Court oral argument, is maybe he just wasn't ready for this question. And that, if true, would be really surprising, because the Supreme Court for many years, and especially as the Supreme Court's become more conservative, has been very concerned about identifying limits on federal power. anytime a case comes up where Congress is asserting a very robust, muscular power to do something, whether it's regulating commerce or enact laws to protect civil rights or to impose conditions on the receipt of federal spending, any of these sorts of contexts, one of the first questions that is always asked of Congress is, if you can do this, what can you not do? What is the limit on your power? So it would be really surprising if the House of Representatives attorney had been unprepared for this question. Although, given the way he fumbled around when asked this question repeatedly by different members of the court, some of us certainly thought that was a possibility. Another possibility could be simply that the House of Representatives, as his client, didn't want to admit any limit. That perhaps the House of Representatives believes, as a matter of principle, that it's allowed to investigate anything it wants. That in the process of figuring out whether or not legislation is working or whether new legislation is needed, the House of Representatives needs to be allowed to be the judge of the scope of its own investigatory power. And, if that was the position of his client, well, then he couldn't admit to any limit in this case that his client was not willing to admit. So it's possible that this was something simply that the client, was something that was dictated by the client. Either way, it was pretty clear during oral argument that the House of Representatives' refusal to acknowledge a limit on its power to investigate the president, including the president's private records, was of great concern. And I think the best illustration of this at oral argument was a comment made by Justice Breyer, a Democratic appointee to the court, one of the court's liberals. During oral argument, he said that what I hold today will also apply to a future Senator McCarthy asking a future Franklin Roosevelt or Harry Truman exactly the same questions. That bothers me. So what do I do? And it was a very Breyer question. Breyer asks these sorts of the what do I do question all the time in oral argument. He is regularly asking attorneys, I'm concerned about this, so tell me how to address that concern and still side with you. And the House of Representatives didn't really have a good answer. Justice Breyer, who I would note wrote a separate opinion in the Clinton versus Jones case, not disagreeing with the Supreme Court's judgment in that case, but expressing concern about the potential for politically unscrupulous actors to use litigation or investigation as a way of trying to interfere with or obstruct with a president they don't like. This is something Justice Breyer was concerned about in the Clinton litigation, and he clearly is concerned about it today. And in the lead up to this question that I have on the slide, he really wanted to concern about, look, let's assume that there are good reasons to want to investigate Donald Trump. I confess, I think there are. We have not had a president with this degree of financial entanglement, this degree of financial relationships with entities that have overseas entanglements, this degree of alleged financial improprieties, this degree of other behavior that I think is worthy of investigation. Right? This is not something we have seen in modern times. Jimmy Carter put his peanut farm in a blind trust, right? We've seen nothing of that sort here. So I'm very sympathetic to the idea that as citizens, we want to know about this information, and that Congress, in the context of investigating compliance with the Emoluments Clause, or investigating whether or not the president is financially or otherwise compromised by foreign interests, should be able and should want to investigate these sorts of things. But Justice Breyer's concern is also a powerful concern, because the point he was making is, look, if we say Congress gets to do this, then Congress gets to do this. And it won't be up to us about whether or not we like or don't like Congress's reasonings. because here, as in the Vance case, the claim before the court was, is the president immune? President's opinion. Does Congress have the power to do this? Not, should we as a court be in the business of looking at the details, right? This was not a case about the specific details of the specific documents Congress was requesting, but whether or not, on the one hand, the president was immune, or on the other hand, Congress had the power to do this. And there was a general recognition that if Congress has the power, then Congress will get a fair amount of deference in how it exercises that power. And Justice Breyer was one of several justices to raise this concern. Now, while this was a concern raised during the case, ultimately the court decided 7-2 in favor of Congress having the power. So rejecting any claim of immunity or any claim of Congress lacking oversight power. And the lineup was basically the same as we saw in the Mazars case. The one difference is that Gorsuch and Kavanaugh, the two justices appointed by President Trump, did not write separately. They joined the opinion of the Chief Justice in its entirety. And it's worth pausing right here just to note that the two justices, or pausing to stress, that the two justices appointed by President Trump sided against President Trump in both of these cases. There was a lot of discussion and concern that the president would be nominating people to the Supreme Court that would protect his interests, that would serve in some way to put his interests ahead of those of the nation. And in the two cases where this was kind of most put to the test, we saw the justices that he appointed rejecting the president's position. And so here, they joined Chief Justice Roberts' opinion in full. Justice Alito and Justice Thomas, as in the Vance case, accepted large aspects of the president's claims. Justice Thomas essentially raising questions about whether or not Congress could seek this information from any private individual pursuant to its oversight powers. And Justice Alito concerned very much with the breadth and scope of these subpoenas, which were really quite dramatic. I mean, among other things, Congress was demanding financial records of Baron Trump and his checking accounts and so on. I mean, these subpoenas were quite broad. So at a macro level, the court affirmed that Congress does have the ability to engage in oversight, and that this oversight does reach the president's private financial records, and that it is something that Congress can pursue. The court also noted that here, as in the Vance case, there is no claim of executive privilege because there is no claim that these are government documents. These are not documents about the president meeting with White House counsel Don McGahn or meeting with the Attorney General or anything like that. These are the president's financial records. So at that level, this case was a victory for Congress and a defeat for the president. But at another level, the case was something of a defeat for Congress in that the court did put some bounds or some checks on the scope of what Congress could demand. So the court, while rejecting the president's arguments, also rejected the broad positions staked out by the lower courts. So both the DC Circuit and the Second Circuit had essentially said that Congress can demand the presidential documents that it wants. These lower courts suggested that there are not real separation of powers concerns because these are private financial documents. These are not White House documents. And that therefore there was no reason to simply not give Congress what it wanted. The court rejected that position as well. Even though these are private financial documents, the court made very clear that there are very real separation of powers concerns anytime one branch is investigating another. So just as there would be separation of powers concerns if suddenly the Justice Department tried to indict members of Congress for various things, we would worry about that. We worry about Congress seeking this sort of information from the president because we all know that the reason Congress wants this information is because Donald Trump is the president. And so Chief Justice Roberts' opinion went on to identify a set of factors that he said, or the court said, lower courts would have to consider anytime they are faced with this sort of conflict, of a conflict of Congress demanding financial records, and that these considerations apply even though Congress is not demanding these documents from the president directly, but is demanding these documents from third-party custodians, demanding these documents from Trump's accountants and Trump's banks. And so here are the list of things that the court said have to be considered. First, Chief Justice Roberts wrote that the court has to consider whether or not a legislative purpose requires papers from the president. And this is important because this is not like Congress demanding, say, information about the Secretary of Transportation, because the Secretary of Transportation heads a department that Congress created. The Secretary's position as a cabinet officer was created by Congress. It is derivative of Congress's powers in that respect. The presidency, on the other hand, is created by Article 2 of the Constitution. So there is a need to demonstrate an actual legislative purpose, and the court rejected the idea that if Congress is interested in reforming the financial system, that it could just randomly select the president to be the case study of how financial transactions work and how people might be evading existing financial regulations. In effect, the court was suggesting that was a bit too cute. We all know that the investigation of the president's financial records is about concern that Donald Trump is engaged in financial improprieties, that Donald Trump may be compromised by investments where there is a Russian connection or a Turkish connection, that the Financial Services Committee is not really interested in using him as a case study. They're interested in investigating him because he may be breaking the law. And the court suggested that we have to be careful there because Congress is not able to prosecute the president. Congress can investigate the president for legislative purposes, if there is a legislative purpose, and Congress can investigate the president for purposes of impeachment. As I noted earlier, that was not on the table here. In effect, Congress has to announce or declare or assert the power it is using when that power is being used. And if it's saying it's just using its legislative power, then it has to have a legislative purpose. And investigating potential criminal or other wrongdoing by an individual is not a legislative purpose. That's a prosecutorial purpose. So that's the first thing that has to be considered. Second thing that has to be considered is the request broader than necessary? Right? If concerned about the president being compromised by foreign investments, well, are these sorts of records actually tied to that assertion? Third, whether Congress has offered any evidence of the valid legislative purpose. So it's not just that Congress gets to say so. We actually look and see, have they substantiated that? And then fourth, whether or not the request would impose any sort of undue or unreasonable burden on the president. Now, if you look at these factors and the way they were explained by the Chief Justice in his opinion, it is probably the case that at least some of the documents that Congress suggested are documents that Congress could obtain. But I think it is also probably the case that some of the subpoenas could not satisfy these factors. And note, these are a set of factors that were agreed to by 7 justices. There was no member of the court that adopted a broader view of Congress's legislative powers here. Right? There was no separate opinion by any of the liberal justices saying, no, Congress can do more. There were 2 opinions by Thomas and Alito saying Congress could do less, but no opinions that Congress could do more. If you look at the actual subpoenas, it's probably the case that the House Intelligence Committee subpoena is the easiest to justify under these factors, or at least the easiest to justify in most of its particulars. Now, there may be aspects of it that would be hard to justify here. And why did the court adopt these 4 factors? Well, I think there are 2 reasons to keep in mind about why these factors were what the Chief Justice focused on. First, a point that I've already talked about a little bit is this need for there to be limits. The court felt that the Congress's oversight power, like its commerce power, like its spending power, like its civil rights power, is subject to limits, and that those limits can be judicially enforced. And so the court felt that it needed to identify some limits. Second reason I think it looked at these factors is the court was very conscious of the fact that this sort of dispute between Congress and the president is kind of rare. It's not that Congress doesn't usually demand documents from the White House or documents from the president. It's that what usually happens is Congress demands documents from the White House or from the president directly. Usually Congress is demanding documents, official documents from the executive branch or White House directly. And then what usually happens, to use the phrase that the Chief Justice used, is a hurly-burly of political maneuvering, where Congress demands documents from the White House. The White House says no. And then there's a bunch of negotiating. There's a tug of war. Congress threatens to do things, cut off funding, not approve things that the president wants, not approve a nominee. And there's usually some back and forth. And then ultimately, the White House agrees to give at least some of the documents that Congress is demanding. It's rare for Congress to seek subpoenas against the president directly or against the White House directly. That's something that has very rarely happened. And it is rare for Congress to demand private financial documents. And it is particularly rare for Congress to seek documents about the president from third parties. One of the things the court noted is that the usual process of negotiation was completely evaded by Congress deciding to file subpoenas with Mazars and Deutsche Bank rather than with Trump directly. Now, the reason Congress did this is probably because Congress believed that Trump would say, get lost, if the subpoenas were served on him directly. And Congress was trying to avoid that. And as Congress predicted, Mazars and Deutsche Bank said they would comply with the subpoenas if they were told to by the courts. But Trump sued to quash those subpoenas. And the court was cognizant of the fact that because Congress was serving these subpoenas on third parties, as opposed to on the president, the normal room for negotiation wasn't really there. And it, in these factors, was in many respects trying to approximate the sorts of considerations, the sorts of arguments that would be made for and against a document request if Congress were actually negotiating with the president or with the White House directly. And so I think it's one way to understand the court's opinion here is that kind of saying, look, we don't want to be in this business of adjudicating document requests between Congress and the president. You guys usually have found a way to work it out. These are the things you've usually focused on. So if you force the federal courts to be involved, we're going to tell the federal courts to focus on the things that we would usually be focused on, because that will approximate the normal state of affairs. And again, that was agreed to 7-2. Note again, as in the Vance case, there was no a claim of any sort of immunity that was accepted. No claim that the president has to, or no claim that these documents are subject to the same sorts of protections that apply in the context of executive privilege. The court rejected those sorts of claims, but it also rejected the claim from Congress that it could seek anything it wanted. And so it remanded these cases back to the lower courts to consider, in the first instance, the precise documents requested by the congressional subpoenas and to consider whether or not these subpoenas comply with the test and that the court set forth. So an obvious question is, well, if this is what happened, and on the one hand, it's a loss for the president in that his claims of immunity were rejected again, but on the other hand, it's a loss for Congress because Congress doesn't get, did not get its virtually unlimited assertion of authority reaffirmed. In fact, quite the contrary. The court recognized limits on its investigatory power. Additionally, a loss for Congress because, unlike in the Vance case, the matters left to be dealt with on remand in the lower courts will require much more extensive briefing and consideration than in the case of the grand jury. So it's not clear that these cases will be done by January. And in January, when the current Congress will end, a new Congress will be constituted. And if Congress wants to, if Trump is still in office and Congress wants these documents, it would have to start all over again. So while Congress would be allowed to disclose any documents it obtains with a subpoena, Congress might not get these documents in time for the election, let alone, or even in time for the end of Trump's first term. Again, we don't know what will happen, whether there will be a second term. So an obvious question is what else Congress could have done. Did Congress have any other options? Well, one option Congress had that Congress doesn't like to use very much, and especially does not like to use against the executive branch, is something called the inherent contempt power. So Congress has the power to issue subpoenas pursuant to investigations and oversight that are related to its legislative powers. And Congress also has the power to enforce those subpoenas, quite literally. So historically, what this meant is Congress would send the sergeant of arms to go get the person that has been called to testify and to physically detain them if necessary. There is a jail in the Capitol building. They've at times put people up in hotels. And then that individual, once detained, could file a petition for a writ of habeas corpus saying they are being detained unlawfully, and then the courts could adjudicate it that way. Congress doesn't like to use the inherent contempt power because Congress doesn't like, on the one hand, it does not like the political atmospherics, the image of Congress sending out the sergeant at arms to go detain people. Two, Congress, I think, is legitimately worried about what happens if the person subject to the demand says no. Congress sought documents from White House counsel Don McGahn. Let's say Don McGahn's in the White House and the Congressional Sergeant at Arms shows up. What does the Congressional Sergeant at Arms do when the Secret Service doesn't let him in? What does the Sergeant of Arms do if the Secret Service protects the president or an executive branch official from being physically detained? That sort of potential conflict is not something any of us think would be very good. Our politics are partisan and nasty enough as it is. Just imagine what it would be like if Congress is sending out the Sergeant of Arms to arrest members of the executive branch. So legally, that's an option Congress had, but it's not one Congress is very interested in. Another possibility would be Congress's use of the impeachment power. As with the Nixon impeachment and the Clinton impeachment, Congress has very broad power to investigate impeachable offenses. And unlike the oversight power, the impeachment power is a prosecutorial power. That is to say, the process of impeachment is a power to investigate wrongdoing by impeachable officials. It is precisely the sort of power that involves investigating documents for the purposes of disclosing wrongdoing that can then be prosecuted or acted upon. And if you kind of think back to, the nation's founding and the ideas of separation of powers that the framers had, as a general matter, we have a separation of powers. Executive branch with executive power that includes prosecutorial power. A legislative branch with the lawmaking power. A judicial branch with judicial power. So as a general matter, we have these three branches that each have their own distinct sorts of powers. But we also have checks and balances. We also have little bits of overlap among the branches. So while the executive power includes the power to appoint people, there's advice and consent in the hands of the Senate. That's giving the Senate a little bit of power to check the executive's exercise of executive power. The Congress has some power to control federal court jurisdiction. That's a bit of control over the judicial power. The president has the power to veto legislation. That's the president having a bit of intrusion on the legislative power. And likewise, the impeachment power, while it is housed in the legislature, is in effect a sort of prosecutorial power. But it's the sort of prosecutorial power that is necessary because we don't expect the executive branch to investigate itself, or at least not very effectively. And so the power that Congress has to investigate with the impeachment power is qualitatively different from the power that Congress has to investigate when using the legislative power. And as I mentioned before, the House of Representatives didn't say they were using these subpoenas for impeachment. These subpoenas were issued prior to the impeachment of Donald Trump, and they were not related to. They concerned matters apart from those that were a part of the impeachment proceedings. Now, an obvious question is, well, why didn't Congress use the impeachment power? And that's a good question. I think part of the reason is that invoking impeachment is a big deal. And early on, prior to the completion of the Mueller investigation, there were at least some members of Congress, some Democrats in Congress, that didn't like to acknowledge that that impeachment was on the table, and didn't want any of these investigations to be considered to be pursuant to or in anticipation of impeachment. And so when these subpoenas were issued, they were explicitly issued as solely exercises of legislative power. I actually think that this is kind of how the system is supposed to work. Right? Impeachment is a very powerful tool. We think impeachment is important and worthwhile, and I certainly am among those that believe it was proper for the House to impeach Donald Trump and believe the Senate should have convicted him. But we recognize that impeachment is a big deal because it can involve removing the president from office. And so we don't want members of Congress to invoke the impeachment power lightly. And so if what Congress is doing, in effect, is the sort of investigation that should be an investigation of impeachment, we should want members of Congress to be willing to own up to that fact, to admit it. Because the only check on the impeachment power is political. If impeachment came to the courts are going to say, this is a political question. We have no say about this. And in fact, there have been cases holding precisely that. So the only check on the House's power to impeach and the Senate's power to convict is the political process. And for that political process to work, it is proper to put the constraint on Congress of requiring Congress to admit when it is engaged in or thinking about impeachment. And Congress didn't do that here, so Congress couldn't resort to the impeachment process. I see there's a question in the chat about how we went through impeachment process of the president. Yes, we did. We impeached the president for particular offenses related to the Mueller investigation. The president was not impeached for any alleged financial improprieties. He was not impeached for failing to disclose his tax returns. He was not impeached for failing to divest himself of financial interests that may cause a conflict of interest. He was not impeached for violating federal conflict of interest laws with regard to the GSA lease governing the old post office building, and so on. He was not impeached for any of those things. And these subpoenas were not part of the impeachment inquiry. They were not issued by the committee that passed the articles of impeachment, nor were they issued pursuant to the investigation that led to the impeachment articles. They were separate. And the Supreme Court paid note or took note of that. What this means is that the president's financial records might not see the light of day before the election. I don't think Congress is going to get their hands on these documents, because I think the standards that are applied to congressional investigations under the Mazars decision will be hard to work through between now and January. I should say, it's not clear to me that there is any voter in the country whose decision whether or not to vote for or against the president is likely to be influenced by anything in these financial records. That's my amateur political prognostication. If you don't like the president, you don't need to see what's in those documents. And if everything that is known about the president hasn't convinced you to vote against him, I doubt there is anything in his financial records that would change your mind. I think that people who, people's opinions are pretty much made up, but then again, we shall see. The court will reconvene again, as I mentioned, on the first Monday of October. It does have at least one case on the docket this term that is related to this oversight question. There is a case concerning Congress's ability to obtain grand jury materials from the Mueller investigation. And the court will be deciding that. So there is one more case, at least related to these matters. The Supreme Court will decide. Otherwise, the coming term does not, at least does not yet, have many matters that are related to this. So I will stop there, and happy to take questions for the remaining bit of time. Let me do that, and let me stop my screen share. A couple questions. Sloppy lawyering, maybe. As I said, one thing that was really clear leading up to impeachment was that some portions of the Democratic caucus in the House of Representatives was not willing to invoke impeachment. There were some members of Congress who believed that politically they needed to be able to go home and say that to their constituents that they were worried about passing legislation. They were not worried about impeachment. And so long as that was the case, Congress was not going to authorize impeachment articles or impeachment investigations. And I don't think that's sloppy lawyering. I think that's the political process working, in the sense that if a member of Congress's constituents don't support an impeachment inquiry, then I would expect a member of Congress to take that into account. And I say that as someone who believes the president committed impeachable offenses and believes the president should have been convicted. But I also think that the impeachment process should be responsive to the political process. As for the oral argument, there may have been some sloppy lawyering. I mean, as I already discussed, everyone knew that somebody was going to ask what the limits of Congress's investigative power was. And not only did somebody ask, but I think at least 5 justices asked about that, if not 6. I mean, every justice was like, okay, what else can you ask for? And I think there I think that the House's lawyer needed to have an answer to that, but didn't. Looking at older questions, I don't see questions from 136. Mentioned that. Let me see. Have other presidents defied court orders? I don't think there have been any. I don't think the president hasn't defied court orders yet. Appealing a court order, seeking review, is not defiance of a court order. Now, refusals to testify, that has happened, unfortunately, a fair amount. And this administration has been more obstinate in refusing requests to testify before Congress than prior administrations, but there is a fair amount of that, and there historically has been a fair amount of refusal to turn over documents that Congress has demanded. The difference is that usually then Congress imposes some sort of or threatens some sort of repercussion.
Okay, yeah.
Sorry? Oh, do we really have checks and balances? Well, you know, we have a very obstinate president. We have a Congress that arguably is not doing its job. And my own view is that much of the fault there lies with Congress, in that Congress doesn't legislate. So Congress doesn't use its most powerful weapon to limit executive power. Congress does not engage in a regular budget or appropriations process, which has also been the way that Congress has disciplined the executive branch. When Congress is doing the regular appropriations process, Congress has the ability to say, if you don't testify, your cabinet department doesn't get money. Or even your office doesn't get money. Congress has actually threatened that. There are examples of Congress saying, we'll give your department the money except for your job. You know, the undersecretary for whatever won't testify. The undersecretary will not have a salary. That only works if you have a traditional appropriations process where Congress is approving the Department of Justice's budget and then the Interior Department's budget. When everything is at the end of the year, one giant omnibus appropriations bill, that's a must-pass bill. You're not going to shut down the entire government because one executive branch official won't testify. Right. In the case yesterday, I believe it's the Assistant Attorney General for the Office of Civil Rights. You're not going to shut down the entire federal government over that one guy's refusal to testify. But you might not give the Justice Department its appropriations over that one guy, or you might be selective in what you give the Justice Department. So my own view is that Congress has progressively over the last several decades tied its own hands behind its back and become impotent. And I think that has made it too easy for a president like Trump to behave the way Trump has behaved. And unless and until we have a elected president that won't behave that way, Congress has to be more proactive in using its powers. I have not read Andrew Weissman's book, so I can't comment on that. The president is immune for official functions in that the president is not liable personally for official actions. The federal government can be liable for the president's actions only insofar as the Federal Tort Claims Act waives sovereign immunity. And again, defamation is not part of that. The general understanding is if the president misbehaves, it is up to Congress to impeach and the Senate to remove if Congress and the Senate believe that is justified. The link to the Ginsburg thing is up again. What are the issues with the 8-person Supreme Court? Well, one is you can have 4-4 splits. We had them after Justice Scalia died. We've had them previously when vacancies weren't filled very quickly. For example, that happened after 1968. Would a new Supreme Court justice be able to vote on cases that were filed or argued before? Filed, yes. Argued, no. Supreme Court justices traditionally only vote on and participate in cases if they are on the court at the time of oral argument. If the court is split 4-4, or if the court believes that they would benefit from the input of the new justice on a case that was argued before that justice joined the court, then they would reschedule that case for re-argument. If someone is confirmed after oral argument, they are confirmed after that case was submitted. Unless the case is re-argued, they do not participate. How can Congress legislate appropriate when Mitch McConnell doesn't even bring bills to the floor? Short answer there is it's a bit more complicated than that. So for example, the COVID bill, or a COVID bill, was brought to the floor. It was filibustered. And there are ways to make things painful on the Senate Majority Leader if he won't bring bills up. And if it's things like funding the federal government, well, those bills have to pass. So I think we've seen a system whereby the legislative minority, especially in the Senate, has been particularly lazy, unfortunately. Couple other quick ones. What can be done by Congress to stop the Supreme Court nomination from going forward? Well, the House can't do a lot because the House has nothing to do with confirmations. The Senate has the advice and consent power. The House does not. If the House were to vote out new impeachment resolutions, the Senate would have to deal with them, but the Senate could simply dismiss them by a quick vote if they were frivolous. So that would not be much. Now, what can the Senate do? Well, one of the things the Senate can do is it can refuse unanimous consent for certain types of operations, which would prevent committees from, for example, holding full-length hearings, and that would lengthen the hearing process. That is something that could be done. If the new justice is confirmed before the new election, how soon after that can the new justice sit and hear cases? As soon as they are sworn in. So that could be the same day of the confirmation vote. And it was not so long ago that we had justices confirmed in 30 days, 40 days. The current average since 1975 is approximately 70 days between nomination and confirmation. Ruth Bader Ginsburg's was about 40 some days between actual submission to the Senate and the confirmation vote. In terms of history, Frank Murphy in 1940 was confirmed in 12 days. But back then we didn't always have hearings. So it's really a question of what the Senate is willing to do. Doesn't the House Counsel really represent the majority party, not the entire House? The answer is both, right? So the House is a fairly majoritarian institution. So if a majority of the House votes for the House to be represented by the General Counsel and to take a certain position, then that is the position of the House of Representatives. Yes, if a majority votes for a particular position, that is the House's position. Might have time for one more quick question. There is another one.
If the president has absolute immunity for official acts,
Yes.
how could the Supreme Court order Nixon to release his tapes?
Because, so it's a good question. So in United States versus Nixon, the subpoena at issue was a subpoena duces tecum, which was a subpoena for materials held by a third party. So Nixon was not indicted. Rather, his compatriots were under criminal investigation. The Archibald Cox's view was to know what Nixon's compatriots did or did not do, it was necessary to seed Nixon's documents. And the court's view was that it would be prejudicial to the administration of criminal justice if those documents, which were clearly relevant to the prosecution of other people, could not be obtained for purposes of investigating those people. So both those other people's criminal wrongdoing might escape prosecution if those documents weren't disclosed. But also, and equally important, let's say those individuals had defenses that were dependent upon being able to show something that Nixon did. Well, the criminal justice system is just as concerned with that information. And so for their ability to defend themselves, it would be necessary for these documents to be disclosed. And in United versus Nixon, the court said there is a balancing test. And on the one hand, the administration of criminal justice is a very, very, very important interest, right? Someone's guilt or innocence of a criminal offense would be at risk. And on the other hand, Nixon was not able to claim that any sort of pressing interest existed on his side of the ledger, right? He could not claim that the documents at issue were related to national security or intelligence or the sort of thing where executive privilege would be very, very important. And so in that balance, the fair administration of criminal justice on the one hand, and just generic White House secrecy because the president likes it on the other, well, the criminal justice concern is a greater concern. So that was the basis of Nixon. And, just to think about things that could arise in the current context, phone calls with a foreign head of state, well, that would be a very different question, right? Because there, even if we were concerned about administration of criminal law, the president's ability to claim executive privilege would be much greater in a situation where the documents in question related to foreign policy or national security. Thankfully, we haven't had a Supreme Court case presenting that precise scenario, but it's certainly one that we could imagine. And with that, we're 2 minutes over, so I will stop. But thank you all. I like it better when I have you all in person. Hopefully, we'll be able to do that next year. But stay safe and stay well. And it was my pleasure to be able to speak with you today.